I have been getting a lot of calls lately on the subject of going to jail for being in debt. Awful lot of people I'm hearing from are worried about the prospect of going to jail because there was a big article about it in the Star Tribune not too long ago. I have been reassuring them that it is not very likely. Before a creditor can get the sheriff or the police to go pick you up, there's quite a process that they have to go through. Generally what happens is the debtor gets sued, and because they don't really have any defenses, they actually owe the money. There's not much they can do, and a judgment will be entered against them. But once the judgment is entered, the creditor has a right to check on, inquire into, ask questions about assets that might be used for the purpose of paying the debt. And they have a right to demand documents, they have a right to ask questions, and they have a right to have the questions answered and the documents produced. And by the time the debtor receives the questions or the demand for information, they've already got this stack of paper and they don't know what it is, and they've been ignoring all that stuff for some time. So they don't respond, and then the next step ordinarily would be that the lawyer for the creditor is going to ask for a court order requiring a response to the questions or to the demand for information. So a notice comes that there's going to be a hearing. The debtor ignores it. Hearing takes place. An order is issued requiring that a response be made to the inquiry about assets, whatever it is. Usually it's just a list of questions or a form they want you to fill out, something like that. Where do you bank? Where do you work? That sort of thing. Okay, so a process server comes by and hands the debtor the order, requiring them to answer the questions or fill out the form. Well, by now, that debtor's not going to respond. They're in the habit of not responding to anything. They've got such a stack of paperwork, they don't know what to do with it. They may just shred it and throw it away. So no response is made, and a court order has been disobeyed. Do they go to jail at this point? No, they don't. Another hearing has to be held. The lawyer for the creditor has to go back to court and make another motion, this time asking that the debtor be found in contempt for not obeying the court order. Now, ordinarily, when a hearing is scheduled on a contempt motion, another court order is issued. Now, this is already the second court order. This court order requires that the debtor appear at the hearing, and that is served on the debtor, and the debtor ignores it and doesn't go. So now we have a hearing where the debtor's been ordered to show up, doesn't show up. At this point, this is already the second time there's been a hearing in front of this judge. It's already the second court order that's been ignored. At this time, the judge will issue or can issue an order requiring or allowing the deputy sheriff, usually it's the sheriff, to go and pick this person up for contempt and put them in jail. And it is a long and lengthy process, and there's so much paperwork and so many times you get served with a notice that it's always seemed to me that it would be pretty hard to just completely not be aware that this thing is in the works. So the I didn't know that this was coming, this is totally out of the blue, I was totally shocked by this, that sort of stuff that is in the newspaper article frankly doesn't ring true to me. I know an awful lot of people said that, people said that to the reporters, and the reporters who wrote the article are reporting what people said to them. But I want you to know that you almost have to be trying to get arrested for this to actually happen. And it has not happened to any client of mine ever, at least not while they were my clients. I did have a case once where I was hired to file a bankruptcy for someone who already was in jail, and yes, a bankruptcy filing will result in the person being released. That was a big day in my life. Started going to the jail, getting my client's signatures on the papers, filing them, going and getting a court order from the judge who had ordered my client to be held, now order releasing him, going back, picking him up at the jail and bringing him home. I would probably not want to do that again, but I guess I'm glad I had the experience. Long story short, if you have paperwork that has been handed to you or sent to you by an attorney, and if you do not know what the paperwork is or what it means, please at least consult with somebody and find out what it is that you have there. Most of us at least will talk on the phone for free. I spend hours on the phone every day answering questions. Get to legal aid, get to the Volunteer Lawyers Network, get somewhere, but get some advice about what the paperwork is. And if you are handed anything that has a judge's signature on it, or anything that has a seal from the court and a clerk of court's signature on it, and that would, I'm thinking of subpoenas now, anything that looks like it orders you to do something and has either a judge's or a clerk's signature on it, pay attention to what that is. Seek some advice about what it means and do what it says.